So the state understands that the state, Mr. Brimhall and Ms. Biggs agreed to do a final order today. Regarding what the state's interested in, essentially keeping all the financials that are currently in the order the same, the current child support, current medical support, health and the government medical. Um, as for the retroactive support, Your Honor, the state asked the court to order retroactive child support timeline of August 1st, 2023 to July 31st, 2024. August 1st is when uh, it's the month after Mr. Garcia got out of prison. And July 31st is the day before the last ordered current child support. Um, the total amount is $4,730. And the repayment that the state recommends is $74. The state understands that Mr. Brimhall and Miss Biggs agreed to that timeline and those amounts. The state predicts Mr. Brimhall to regarding the conservatorship to allow Mr. Garcia to keep the typical rights um, that are in there because in the further temporary order, Your Honor, Mr. Garcia's rights were reserved until further order. So basically, Mr. Brumal would like that to just be that until further order just be cut out. He received the normal rights. Um, as for visitation, I state predicts that Mr. Brimhall would be asking for some changes to the visitation. Essentially, first, the visitation currently right now, Your Honor, is 3 p.m. to 6 p.m. on the first, third, and fifth Saturdays of each month for 12 periods of possession, supervised at this park or a public place. And then after that, 3 p.m. to 6 p.m., basically same time period, but six periods of possession, no supervision. Um, I believe Mr. Brimhall will be asking for the first 12 to be changed to 11 as Mr. Garcia has already done one. Change the park location to a park in Marble Falls called Johnson Park. Add in a notice requirement of 72 hours notice before any visitation. And then the 6 that would come after the, I guess, 11, change that until further order, with exchanges being at that same park. And then I believe Mr. Brimall will also be asking for Mr. Garcia to provide proof of driver's license when he gets one within 7 days of receiving one. Um, and I think everything else as is, Your Honor, from the further temporary order.
All right. Thank you very much, Mr. Wells.
Judge. Oh, sorry. Yes, I was going to say the state did a pretty good job announcing what I had intended on announcing. The court had wanted information about Mr. Garcia's criminal convictions. There was a criminal plea that was done in June of 23. The underlying offense was for manufacture or delivery of a controlled substance. And he pled to 10 years probation for that. I think there was some jail time that was contingent upon him. Like if he failed the probation, then he would be sent to TDCJ for some time. My understanding right now, though, Judge, is that he doesn't have a current driver's license. I've been told that he probably is driving about, but without a license. So there's the potential if he's pulled over that he may catch a misdemeanor for driving without a license, which would, of course, be a violation of the probation. So my recommendations on the visitation, currently they're supposed to meet in Copper's Cove at a park. Miss Biggs, whose maiden name is Tolk, which is why the child has that name, has indicated to me that she is planning on moving to the San Antonio area to be closer to some family down there. And so she has indicated that she's willing to meet in the middle, which would be roughly Marble Falls. And so from where Mr. Garcia is currently at, he'll of course have to figure out some sort of legal transportation to there. But given all of it, he has not done. Well, I guess he's only done one visit of the court order of visitation since we were here at the beginning of December, and he should have had at least seven Saturday visits, and he's only done one. So to me, that shows some kind of indication of his inability or unwillingness to do those visits. So I think it's reasonable that he continue to do those first steps. Change the park to, it's called Johnson Park in Marble Falls. It's right off of 281. It's not too far off of 281. The 72 hours notice is, I think, appropriate. Ms. Biggs has told me that she's tried to, well, she has sent requests about app close to Mr. Garcia, and he's refused to, or either refused, or I don't want to impute any negative, intentionality on his part, but for whatever reason, he has not downloaded app close and not connected with Ms. Biggs on it. I think he should continue to be ordered to do that. I think it's a good thing. And if he wants to do these visits, it's really not that hard to download the app and give notice in the app to Ms. Biggs. Regarding his rights and duties, because the convictions weren't for any kind of assaultive conduct or family violence conduct, and Ms. Biggs she's not the victim in any of these offenses. I think it's okay that he be named a joint managing conservator. I don't think he's precluded from being listed as a joint managing conservator under the family code because he doesn't have any kind of family violence conviction. So I think just standard joint managing conservator rights as listed in the order are fine. The OGS paperwork, when they draft these, I think is fine as well, because it has Miss Biggs having the exclusive right to do all of the pick the residence and consent to medical treatment and so on. And I think all of that's appropriate. So Mr. Garcia would have just the basic ones, and I think that's fine. And then because of the driving issue, I would like him to tell Miss Biggs when he has obtained or like send her a photo or proof indicating that he has a driver's license. And at that point, certainly that would he can go back to court and request a modification and set up something beyond the 3-hour unsupervised visits that he would be on if he completed these first 11 visits. On the support side, I totally agree with the OAG. Current support should stay the same. That's based on his testimony from the last hearing. And then the retroactive child support judgment that state's announced, I believe, is calculated using his testimony that he was on VA disability, and that was his income for going backwards for the preceding year and a half. There's a little bit added where he actually worked for Miss Biggs for a couple months, and so we added in those 2 months where he worked for her as part of his income. But the number they announced, 4730, I'm okay with. I'm agreeable with. All of those are my requests to the court.
All right, thank you very much. Let's get Ms. Biggs to verify, and we'll end this one and get the orders circulated. Thank you. So at this time, Ms. Biggs, please raise your right hand and unmute yourself, ma'am. Thank you. All right, do you solemnly swear or affirm your testimony going to give here today is the truth, the whole truth, and nothing but the truth will help you?
I do.
All right. All right, I'll go ahead and let the state call you as your first witness. You may proceed at this time, Mr. Welch.
Thank you, Your Honor. What is your full name?
Davina Biggs.
What is the full name of the child in this case?
Grayson Mitchell Garcia Tolk.
When was Grayson born?
December 3rd, 2022.
So how old is he?
He's 2.
So when did you two no longer live with each other?
August of 2023.
And Does Mr. Garcia have any other children?
Yes. He has one other daughter.
And so, how old is that other daughter?
I believe she's 9.
Now, in August 2023, did Mr. Garcia work for you?
Yes, he did.
How much did he make?
Paid $20 an hour.
And how many hours per week approximately?
About 20.
And as far as you are aware, he's was still receiving his VA disability during that month?
Yes, correct.
And do you agree to a retroactive child support judgment of $4,730 based off of timeline of August 2023 through July 2024?
Yes.
And do you agree to a payment on that judgment of $74 per month starting April 1st, 2025?
Yes.
And do you agree, and just to go over what we had previously ordered to make sure you're still in agreement with that, do you agree to Mr. Garcia paying you cash medical of first, and this is the order's divided into two parts, $80 per month beginning August 1st, 2024 until December 31st, 2024, and then thereafter $47 per month starting January 1st, 2025 and continuing thereon?
Yes.
And do you agree to current child support to remain the same at first $588 each month beginning August 1st, 2024 until December 31st, 2024, and then afterward it'll go to $360 per month beginning January 1st, 2025.
Yes.
And do you agree to those do you agree to no non-disclosure?
Yes.
And just want to make sure, what I mean by thereon after the last two for the current child support and medical support, that there are ending conditions that they would remain the same as in the last order.
Yes.
And during the time of that retroactive child support period, had he ever given you any cash or very expensive goods?
No, like I said, he just worked for me.
Pass a witness, Your Honor.
Thank you very much, Mr. Brem, your witness.
Is the child's last name Tolk-Garcia or Garcia-Tolk?
I'm sorry. I think it's Tol Garcia. My mistake there.
I just wanted to make sure it was whatever it needed to be.
No, that was my mistake.
No, it's okay. So it should be Tolk-Garcia.
Correct.
Okay. Is Mr. Garcia, is he a veteran of the United States Armed Forces?
Yes.
Okay. Do you know if he was honorably discharged?
I believe so.
You get a VA disability, sir. Yeah, you can't get that without being discharged. The court judicial notice of that fact. Thank you.
Regarding Mr. Garcia, y'all were both here in December, correct, for the temporary hearing?
Yes.
And the court later signed this order, the further temporary order, right?
Correct.
Okay. And it was signed by DocuSign by both you and him, is that right?
Yes.
All right. And it contains the information for today's hearing, correct?
Correct.
All right. And he hasn't called you or told you he wasn't going to be here, is that right?
Correct.
All right. He hadn't given you any indication that he didn't say, hey, would you let him know I'm not going to be here? He didn't say
No.
that to you?
No.
Okay. All right. Do you believe he has knowledge of the hearing today?
Yes.
Move on, please.
Okay.
That's totally unnecessary. He signed off on an order to be here, sir. That's it.
Okay. All right.
So,
All right.
if he didn't read it, that's on him. Sorry.
I understand. Okay. Regarding app close, have you downloaded the app?
Yes.
And have you sent him a request to join and
Yes.
connect on there?
Yes.
Has he done so?
No.
Okay. Would you like him to do so?
Yes.
All right. regarding the periods of possession that were ordered on those Saturdays, he should have had at least 7, maybe more, of those Saturday visits. Is that right?
Yes.
And how many has he done since that beginning part of December?
Technically 1.
Okay. He did come over another time just to say hello, but the child was already asleep. Is that right?
Correct.
All right. So really just one time out of a possible 7 or 8 that he saw the child. Is
Yes.
that right? Okay. And are you asking the court to basically continue the what was previously ordered and have him
Yes.
finish out the 12?
hmm
Okay.
Yes.
And giving him credit for just the one that he did?
Correct.
All right. Are you planning on relocating to Bexar County, San Antonio area?
Yes.
All right. And are you asking the court to adjust the park in the temporary order from that park in Coppers Cove to Johnson Park in Marble Falls?
Yes.
Okay. Are you asking that Mr. Garcia provide a 72-hour advance notice of his intent to exercise one of those visits that's outlined in the temporary order?
Yes.
All right. And if he does 11 more of the 3-hour visits with you hanging around at the park, do you feel it's appropriate that he continue on and do unsupervised visits at that park?
Yes.
All right. Now, regarding his driver's license status, do you know if he has a driver's license?
I don't believe he does.
Okay. Are you asking for him to send you proof of valid driver's license?
Yes.
Okay. Within 7 days of him obtaining one or
Yes.
receiving one? Okay. Um, everything else that's in the temporary order, I guess you understand that regarding the conservatorship status, he'll have some of the basic rights and duties to receive information from important people, including healthcare professionals, school officials, and yourself.
Yes.
You understand that he'll have those joint managing conservator rights and duties that
Yes,
are
I
listed
do.
that are listed on page 2 of the temporary order. And you
Yes, I
agree
do.
you agree with that, is that right?
Mhm.
Okay. Regarding the remainder of your request today, are you asking the court to finalize the further all the remaining unchanged portions of the temporary order from December?
Yes.
Okay, I have no other questions.
All right, ma'am, I'm looking at granting everything that the state and the ad litem are requesting. I'm going to go ahead and keep the old order as is. I'm going to name you both joint managing conservators. I'm going to give you the right to decide domicile. That right's going to be unrestricted. You can live where you need to. I'm going to go ahead and keep the current visitation package, giving him credit for the one visit he has, but order him to complete the others, and then he can move over to that second level. But that's as far as we're going to go into a further order of the court. I'm going to go ahead and grant the child support, cash medical, the retro and repayment is all requested. I'm waiving court costs due to military service, and ordering him to maintain, ordering you to maintain app close, and ordering him to make communications through app close. That's the only official way the court will accept it. So if he wants to have that visitation, he needs to do it through app close. Otherwise, it's left up to you, ma'am, to do it one way or the other if it doesn't come through app close. All right.
Okay.
All right. So, ma'am, do you have any questions?
No, I don't. Thank you.
All right. All right, Mr. Welch, is there anything else, sir?
Your Honor, I guess 3 things. Well, first thing, I just want to make sure Your Honor, you understand, since we don't have a, for the retroactive child support, we did he had testified before the 21006 for his VA disability. Since we don't know for sure how much he made in 2023, but we figure it's probably something similar to that. We used the 2106 for the August for the timeline, and then for August in particular, adding in that time that the amount that he got from Miss Biggs. So
Yes,
just
sir. I heard the testimony.
all right. I just wanted to make sure, Your Honor, on the record. Besides that, Your Honor, just so you are changing the park location to
Oh
the
yeah.
Johnson,
Right.
and then the adding in the notice requirement, Your Honor?
I thought the notice requirement was already in there that he was supposed to use that post. He's just not doing it, right? Or are you talking about the 72 hours advance notice?
I believe the
72, Your Honor.
Yeah, I believe the 72 hours would be a new requirement.
All right, then I'll grant that. Yeah, no problem.
And then just and this is more of for Mr. Brimhall. I guess kind of. So for the sixth or the second tier visitation when it's unsupervised, that's just going, so the exchange is going to be at the park, but he can do that. He needs to do that at the park then?
Yes. That's
All
my
right.
understanding. You're correct, Mr. Brimhall?
That's what I would prefer, unless the parties agree in writing to move to a different location.
All right. And the drivers and providing, and that he needs to provide proof of driver's license to Miss Biggs through app close when he gets one within 7 days of getting one.
Right. And if he doesn't have a driver's license if he makes it all the way to getting the visitation where he gets to get the child unsupervised, yeah, he does not get the move to that level until he gets until there's proof of a driver's license. All right. That you need to delineate that in there in some manner, way, shape, or form.
So so the second step is conditional on him getting a driver's license.
Correct. So
All right.
otherwise it stays as that first step until he does.
Okay. Very good.
All right. I think that's it, Your Honor. Thank you.
All right. Mr. Brimhall.
Nothing further, Your Honor.
All right. Well, thank you very much, Ms. Biggs. I'll have the state prepare that order and circulate it with with you and Mr. Brimhall. And obviously we'll still send a copy to the father, to Mr. Garcia, and get this taken care of.
Yes,
Anyway,
sir.
man,
Thank you.
good luck. Good luck to you. Good luck on the move. And
Appreciate it.
yeah, no problem. Marble Falls used to be one of the counties in the counties I used to handle Llano County as a lawyer. So yeah, good old days. So anyway, y'all be safe down there. I'm pretty sure the traffic's bad that way down too. So I used to not see people for miles, and now I doubt that's the case anymore. So
It is. Yep.
so anyway, man, good luck to you and
Thank you.
and your excuse. Thank you, and we're off the record.
Have a good day.
Thank
Thank
you,
you,
Judge.
Your Honor.
Court will note for the record at this time that the child in this matter is going to be 2 years old this December. The state may proceed.
Your Honor, state would like to call Marcy Moore. Ma'am, will you state your name?
Marcy Moore.
And you've previously been sworn in as an expert for child support, is that correct?
Yes, ma'am.
All right. Did you do a wage investigation in this case?
Yes, I did.
What were your findings?
There was no current employer located, but Mr. Garcia does receive VA benefits in the amount of $2,283.01.
And did you calculate guideline child support in this case?
Yes, ma'am. It would be guideline support would be $588, and also medical support was calculated at $80.
And is that how many children in and out is that using?
That's going to be one child before the court and one additional child.
And did you also use the minimum wage presumption for Mr. Garcia as well as his benefits?
Yes,
Okay.
ma'am. The minimum wage of $12.56.57.
I pass the witness, Your Honor.
All right, Ms. Moore, that VA benefits?
Yes, sir.
Sounds like he's above 60%. And I always have a little bit hesitant to use minimum wage when they're above 60, 70%. Do you know what that percentage of disability is?
No, I do not, Judge.
Sounds like it's closer to 90%. He's not at the, so it might be 80. All right, anyway, I'll see if the mom knows what his disability rating is before I include minimum wage based on the fact that he's getting somewhere above 60% VA disability. Anyway, Ms. Biggs, do you have any question of the CSO?
No, sir.
All right, may the CSO be excused, Ms. Hubbard.
Yes, Your Honor.
All right, you're free to go, Ms. Moore. Thank you very much. State can call the next witness.
Your Honor, the state would call Davina Biggs. Ma'am, will you state your name for the record?
Davina Biggs.
And state the name and birthday of the child that you have with Mr. Garcia.
Grayson 12/03/22.
And your child participated in DNA testing, is that correct?
Yes, ma'am.
Okay. Were you able to see those results? Your Honor, do you have the DNA testing results in the file?
Yes, the copy of the had been sent over, and it shows that I'm going to mark these as State's Exhibit number 1. Is there any reason that the DNA test should not come into evidence at this time, Ms. Biggs?
No.
All right, it shows that, DNA test shows that, I think that was the name. Okay, I got the names transposed here. It shows that the alleged father, Mr. Brian Garcia, cannot be excluded as the biological father of the child. Grayson Tulk, probability of paternity is 99.999999998, with a combined paternity index 5.099 billion to 1. The court will also find that Mr. Brian Garcia is the biological father of Grayson Tulk, and the state may proceed.
Thank you. So I noticed that Grayson's last name is Tulk. How is that name in relation to you?
Well, that's my stepfather's last name. And in my previous marriage, I kept the married name Biggs. And so I was going to change my name to Tulk. And when Grayson was born, I just automatically gave him that name.
Okay. Are you still planning on changing your last name to Tulk?
Yes, ma'am.
And in this case, I know Judge had explained in his speech about the last name. Do you have a preference on the hyphenation, if it's Tulk Garcia or Garcia Tulk?
Tulk Garcia.
Okay.
And then real quick, you said you were you Tulk before you got married, or you have a different last name?
I had a different last name.
All right, and you didn't take care of that while you in your divorce, or are you still going through the divorce, or what?
I have, yes, sir, I'm sorry. I have 2 other children with my previous marriage, and I kept the last name to keep the same common name of my children. But now I feel like this child, I don't know. I never thought before about changing my last name just due to my first 2 children.
So you got
So
2 children with the last name of Biggs?
yes, sir.
All right, Ms. Tubbs, the thing is, I know it's easier to change your name when you're getting as part of a decree of divorce. It's really, really legally expensive to change your last name now. I mean, you know, they want to make sure that you're not going to become the new head of Al-Qaeda or something. Yeah, I'm just kidding about that.
Right.
They want to make sure you're not up to something nefarious. And so you got to jump through a lot of hoops when you just go in to change your name in a petition for name change by itself. So you know, realistically, it's probably going to be very difficult. But I'll go ahead and look at it, ma'am. If you're going to tell the court this is something you're definitely going to do, because obviously you still got those other 2 children named Biggs, and there might be a problem with that. So, well, are you sure you're going to do it, ma'am?
I didn't know that was that difficult.
It's not totally done, but yeah, it is. You've got to
And
jump through all
costly.
kind of legal hoops to get it done. It's
Uh-huh.
real easy to do with a divorce, but once you do it by itself, they want to know why you want to change your name now.
Well, then I'll probably just leave it, to be honest with you.
In fact, the easiest way to probably do it is for an adoption of an adult instead of trying.
Actually, that's what my dad was mentioning, to adopt me, but I didn't know if it was
Yeah, that's easy. Once you're over the age of 18, you don't have to have all those lawyers appointed to represent the kids, well, the children under age 18.
Okay.
I've done it back in the day, but yeah, it's a lot easier to get an adoption of an adult. But that's left up to y'all. But again, ma'am, off the top of my head, I just know it's very difficult and it's very expensive just for a name change. Okay.
Okay.
Anyway, we might let's see if we're gonna make this a final, and we'll see what we'll try to do. All right. Thank you.
Yes, sir. Thank you.
You may proceed, Ms. Hubbard.
Does Mr. Garcia currently have a relationship with Grayson, ma'am?
No.
Has he ever met Grayson? Okay. Has Mr. Garcia, not anyone else or him comments made, has he expressed to you any indication that he's willing to be a father, that he's not willing to be a father?
Yes, that he's willing to be a father. He just doesn't make time, I guess.
Does he have the ability to contact you currently?
I'm not sure. I haven't talked to him since right around April, maybe May. The last conversation we had was about potentially meeting at the park so he could see Grayson, and then I never heard back from him.
So if he was unable to contact you, it wouldn't have been because you changed your number or because
ma'am.
you were trying to keep Grayson from being able to see him?
No, not at all. I've had the same information for a long time.
But you are concerned regarding Mr. Garcia and his wife and perhaps some potential drug use. Is that correct?
Also just like, I don't know how this works as far as legal wise, but she did lose her own child.
Okay, here's the deal,
Yes.
ma'am. You can testify to anything you personally saw. You can testify to anything the father said, but you cannot testify to anything else anyone else has told you, even his current wife. That's still considered hearsay. But if he told you something or you actually witnessed something, then you can tell the court about it. Thank you.
So has he indicated to you that children have been taken out of the home there?
Yes, ma'am.
Okay. When did that happen?
July of 2023 or 2022.
Okay. And to your knowledge, those children are not back in the home.
Correct.
Has Mr. Garcia indicated to you that he uses illegal drugs?
I don't recall. I don't think he's ever said. I've seen him smoke spice, but I've never seen him use anything other than.
All right.
And-
Ms. Hubbard, I'm looking at this being an attempt, that CPS thing. I'm not sure if I can name this gentleman the joint managing conservator or not based on if they got any type of findings in that. It sounds like it's more than a year old, so that sounds like that's got to be a court case. But again, you never, these days I never know anymore. Back in the good old days, if they were, if the CPS was in a case more than a year, they better have a court action. But for right now, I'm probably having to appoint in that Litem to investigate that to see what we're looking at and see whether or not I've got to appoint the father a possessory conservator and give him limited rights based on that possessory conservatorship. So it is what it is. Ma'am, I just through a lot of legal mumbo jumbo out there, aren't you? But the bottom line is, under the law, I'm supposed to name him as a joint managing conservator, but because there's been children removed from their residence and the allegations may be toward him, and unless there's an official investigation by an ad litem who can get me copies of whatever's on file or get me copies of whatever CPS has on in their record. Yeah, I'm gonna have to give him a lawyer. I'm gonna have to give the baby a lawyer and have them do the investigation to get that information. Where is the father and his current wife living, ma'am? Which county, which state, do you know?
Coryell County.
Oh, then I got jurisdiction to order people to do things. All right, good.
Your Honor, I think testimony may exclude him for different reasons from being a joint managing conservator. If
Then
the
I'm
court
still
would allow me
talking
to,
let me see what those reasons are. Okay, thank you.
Biggs, are you aware of any criminal convictions that Mr. Garcia has?
Yes.
What are those convictions?
Believe their possession charges.
Okay,
All right, ma'am.
were
Did it
they,
happen before the child was born or after the child was born?
Before I was pregnant with him.
You may proceed, Ms. Hubbard.
are you aware of any delivery of a controlled substance charge?
No,
Okay,
I'm not sure what any of those mean.
it's just different criminal
Not all
charges.
of it. That's why we get to charge hundreds of dollars an hour to keep people confused. There you go. So, how do you know
But-
about, did he tell you about the prior conviction?
Yes, sir.
All right, good enough. And which county was that in, do you know?
Coryell County.
So we got it, we can find this out very, very easily then, thank you.
And so I guess bottom line is you're concerned about your child's safety if he were to go over to Mr. Garcia's house for a visit.
Yes, ma'am. And I feel like initially, especially just until they get to know each other.
And as far as medical coverage, how is Grayson covered currently?
Through the state.
And to your knowledge, Mr. Garcia does only have one other child outside of Grayson?
Yes.
And as far as retroactive, well, if this is a temporary order, we'll get into the issue of retroactive support in a final order, but you are requesting it, is that correct?
Yes, ma'am.
Now, currently, Mr. Garcia has your contact information. Are you concerned at all if he continues to know where you live and how to contact you?
No.
Is there anything else that you want to make sure the court knows that we haven't gone over?
I do want to mention, I guess, last summer there was CPS called due to him being in my home. It was a misunderstanding on my ex-husband's part, but however, Mr. Garcia did not cooperate with CPS. He did not communicate with them, and it did close. They did close his case as a non-conclusive.
Well, now you piqued my interest. You said it was a mistake, but what are we dealing with? What happened and why was it,
Okay.
what happened?
Of course. He was just released from jail and he moved into my apartment with me. But because my ex-husband, I guess, had heard of his previous charges, he wanted to make sure that his children were safe. So he called CPS to do an investigation. And that's when Mr. Garcia left.
All right, but there was no incident, the calling of CPS. It was just a preventive in this type of circumstance, right?
Yes, sir.
All right, then. No, that's not. All right. You know what he was in jail for when that happened?
Possession charges.
And ma'am, do you know what his disability rating is at this time from VA?
Last time we discussed his disability, it was at 60%, but he was working on having it increased.
All right, so it sounds like he may be a little bit above 60% right now. So for right now, I'll look at going ahead and doing something toward that and throwing in something and allowing the minimum wage presumption to be in there because I'm looking at having to come back in a couple of months and we'll see whether or not that is accurate.
Okay.
But my thing is once they get above 60, technically I would do, if I would do the minimum wage presumption, I would do it based on the percentage that they're not disabled. Okay, so but
Correct.
again, we'll
Understood.
find out. We'll try to figure that one out. All right, Ms. Hubbard. Any other questions?
Your Honor.
All right, tell Mr. Brem he's got a new one. Okay, and I'll try not to call him Barnhill like I did the other day and call Mr. Barnhill Mr. Brem. Yeah, Mr. Bremhall's pointed out that on docket sheets he's actually been listed as Barnhill. So yeah, I'm not the only one. So there. But anyway, man, I'm gonna go ahead and give the child a lawyer. I want the lawyer to complete an investigation, get me some evidence that's not considered hearsay. That means evidence that he can present that shows the truth of the matter. In other words, documentation. And lawyers know how to get that entered into evidence and get it done. So at this time, ma'am, I'm looking at naming you and he joint managing conservators. But right now, I'm not looking at giving him any rights until I find out what his criminal convictions are and what the circumstances are and the allegations dealing with the removal of, and are those children with his current wife, his or stepkids?
Stepchildren.
All right, and let's find out what those allegations are before I give him any rights under conservatorship, because again, that scares the daylights out of judges when we don't know what's going on. So I'm gonna go ahead and, like I said, appoint Mr. Isaac Bremhall as the attorney ad litem for your child. I'll need your permission to have the state give him your contact information. In other words, your phone number and your email, and have him do an investigation to see what and hopefully even find out what dad's percentage of disability is, and figure out what kind of rights I can give him under joint managed conservatorship, or if I had to reduce him to a possessory conservator, which is again another legal term that we use in the family code. And give him rights under that, and then limit those rights based on what other the ad litem has been able to find as far as criminal convictions, which will have terms and conditions of any probation he's on, plus anything dealing with CPS and restrictions that they have given. Because again, for CPS to still be on your case after more than a year, yeah, that sounds like it is something really serious, and the court needs that data. So, ma'am, I'll ask you, do you have any questions at this time? I'm going to go ahead and, like I say, name you joint MC, but give you all the rights to decide domicile. I'm going to go ahead and order that any and all visitation into further order are at your discretion, or however you want to handle it. If you want to meet him in the park, you want to have him come over, whatever, you can do whatever you want so long as you feel safe. But until we come back in October, I'm going to set this out to October. It's left up to you about visitation, and I'm going to go ahead and order temporary child support. And I'm going to go ahead and use the amount as testified to by the CSO. But at the final hearing, depending on what that percentage is, ma'am, I'm probably going to tweak it. But since the gentleman seems to have a penchant for using his money to buy drugs, I'd rather go to you than to a drug dealer. Okay, so at this time, ma'am, questions or anything else you think I need to know that you haven't testified to already, ma'am?
He is currently on probation.
Well, I knew that, ma'am. If he's out in the free world, he's got to be on some type of probation, ma'am. So
he completed his parole, and that's when he got in trouble again. So there's that. I didn't know if that would be
No, well, so right now the parole is completed, but he's still on probation for the current for the most recent criminal charges. And I'll have the ad litem, and I'll have the state put in there that Mr. Bremhall needs to get a copy of his terms and condition of probation that's over in that file in Corio County. Believe it or not, a long time ago, the judge practiced criminal law in Corio County, and all that's in the file now. No problem.
All right. Well, no other questions. Thank you.
All right then, Miss Hubbard, look for a date in October and run that by Miss Biggs. I know y'all got to go back in the breakout room to get try to get this temporary order set up and signed off on. So I'll sign off on it once presented. Is there anything else, Miss Hubbard, you think as far as this order is concerned before I go ahead and end this hearing?
Your Honor.
Thank
All right,
you.
thank you, ma'am. We're off the record.